Yes.
Any adjournment request from item number 1 to 7? From item number 8 to 11? Any request for adjournment? Any other request?
Yes.
May-
You want to
Your
mention?
Lordships, yes.
Yes.
I like to mention item number 8.
Item number 8.
Yes, yes, Lordship.
This is that relating to cooperative election.
Yes, Lordship.
Yes.
We were supposed to file an affidavit in
You
opposition.
were supposed to file what?
We were supposed to file an affidavit in opposition today, which has been sent for vetting. We will file it by Monday or any day next week. Lordship.
What do you say?
No objection, my lord.
As prayed for on behalf of the respondent and agreed to by the counsel for the appellant, let this matter come up for consideration. We are fixing it in January. Jan or Feb, whichever. All right.
5-2.
Yes.
Item 17 to 21.
Mr. Chaudhary, we will take up the matter, which is continuation of yesterday. We'll finish it off in about 15 minutes.
Okay.
Then we take up your matter. Yes, Mr. Sharma.
Milord, for the sake of brevity, I shall not repeat what Mr.
No. Please don't take that to heart. I mean, I just said Mr. Goswami was very,
He was very eloquent, so
Very
we adopt the
eloquent, yeah.
submissions made by Mr. Goswami. Only things I would like to bring to your notice. Some points at page 138, my lord,
of the
of the convenience booklet prepared by us.
prepared by you.
Item number 19, my lord, for in today's matter. Item number 19, writ appeal 453.
Mr. Goswami's compilation overshadows all other compilation. No, these are thick ones, and two of this kind. What happened? These also thick. You proceed with the argument. We'll
My lord, at
hear you.
page 138, I'll just go through what is already said. At para 69, this court further finds it relevant to observe that another relevant aspect, that is, except in writ petitions 8220 and writ petition 1931, wherein some semblance of a selection process had been mentioned, there is no mention in other writ petitions about any particulars of the selection process. So, my lord, we are the appellants in writ petition 1931 of 2021.
Yes. Yes.
So, my lord, coming to page 158, my lord, come to page 158. 150.
Yes, page 158.
At page 158 is the communication of the Joint Director Health Services Dibrugarh to the Director of Health Services at Dispur. This is the list of all the grade 4 staff, wherein we have obtained this through the RTI. The letter states by the Joint Director of Health Services, in enclosing here the report of RTI, as stated herewith as per searching the availability of documents in the office establishment. Now, at page 59 is the reference letter. These are the list of candidates with the marks and all these details of the selection process was sent to the Director of Health Services at Dispur on 17th of February, a few days after the selection process was
So
completed.
you mean to say that it had the approval of the competent person and not that the joint director only did it?
No, my lord, they were in full knowledge of the whole the selection process. Now, this letter my lord, brings into play the doctrine of acquiescence. They were in full knowledge of the
Mr.
whole.
Sharma, in service jurisprudence, acquiescence is not something which is pressed. You argue on other aspects.
My lord,
Acquiescence is not applicable here.
my lord, my.
See, if your appointment would have been fake, forced, or
lord.
divorced the rules in a manner in which it could not have been sustained,
My lord,
then probably you could have said that they have acquiesced, but that acquiescence also will have no value. You have other strong point. Acquiescence is not something, you say that they were under the knowledge, it was a regular selection following all rigors,
my lord,
just that there was no proper, SIU approval or something of that kind for which you are not to be held responsible.
my lord,
That's all.
and my lord,
Because we must use the expressions appropriately. Acquiescence in service jurisprudence is no accepted formula.
my lord, continuing with Mr. Goswami's submissions, my lord. He has already taken, my lords, through the recruitment rules of 2007, wherein a substantial portion of the selection procedure has been complied with. My lord, now.
He has also given us a judgment which says that substantial compliance is good enough to
My
sustain
lord.
long-standing employment.
My lord, it has been 14 years we have been working, and my lord, there's other single benches, my lord, had already, my lord,
We have Supreme Court judgments for that.
my lord. So, my lord, I adopt the.
Adopt the arguments of Mr.
Of Mr. Goswami, my lord. Nothing more much to add here, since the recruitment rules have been already been put before your lord.
All right, now let us see what the state has to say.
My entire limp of argument, my lord, of the state will be, my lord, that the entire selection was conducted by both the joint directors of.
By
health
the?
ser- By the joint director of health services, Gwalpara and Dibrugarh, without the authority of the state, in total violation of the provision of the 1977.
And you were sleeping over all this for 14 years.
It was not, I will come to that, my lord, how it came to light, my lord.
Hmm.
Here, my lord, an inquiry was conducted, my lord. For-
When did you begin that inquiry?
Yes. Well, it started, my lord, I will have to, my lord, refer to this. My lord,
Please.
because- Yes. Read appeal 429/2023. 429, volume 1.
Yes.
My
Mr.
lord,
Gogo.
it came to light that in Dibrugarh district, my lord, some surveillance workers, my lord, they were illegally working, my lord, without there being any such selection process. No appointment letters were issued by
No,
the.
tell us
No,
one
when
thing.
it came to light, the government.
These were not, the suspected people whose appointments were forced, fake or irregular. These are not the respondents, so far as you are concerned. These are not
At
the.
least, my lord, in this batch of, my lord, writ petition, except that, my lord, Pradeep Buraguhai, where, my lord, they were contractual employees. Other 4 writ appeals, my lord, there appears to be, my lord, they have annexed.
Actually,
certain
employees who were later regularized,
Yes, that is a separate issue, my lord, not connected.
not a separate issue. It
No, just I'm saying.
merges in the same
fa-
issue. They
factual-
were effectively regularized from service from a particular date.
By the joint director, my lord. Now, entire limp of argument will be, my lord, without authority. I will place one judgment of the Honorable Supreme Court, where the Honorable Court has held that, my lord. If, my lord, the particular authority who has issued the appointment letter or has conducted the selection, it does not have the, my lord, authority to conduct such, my lord, selection, then it is a nullity. The entire case, my lord, started with that was the main issue, and finally it came in favor of the, my lord, state.
Now,
They are also-
which is that judgment?
Yes, madam. It is, my lord, 2018-15 SCC.
Name of the case?
It is, my lord, Union of India versus Raghuvar Pal Singh. 2018-15 SCC 463. In the short note, my lord, I have given the relevant para also. May I read that, my lord? Everything
Yes.
will be clear.
Yes.
The very first para of the judgment, my lord, says, my lord, the central question posed in this appeal are, one, whether the appointment of the respondent to the post of veterinary compounder made by the director in charge at the relevant point of time without approval of the competent authority was a nullity or a mere irregularity, which could be glossed over by the department to avoid disruption of services. Now, my lord, lordship may turn to para 20. Very important, my lord. For taking this contention forward, we may assume for the time being that the then director in charge so-and-so had authority to issue a letter of appointment. Nevertheless, he could do so only upon obtaining prior written approval of the competent authority. No case has been made out in the original application that due approval was granted by the competent authority before issuance of the letter of appointment to the respondent. Thus, it is indisputable that no prior approval of the competent authority was given for the appointment of the respondent. In such a case, the next logical issue that arises for consideration is whether the appointment letter issued to the respondent would be a case of nullity or a mere irregularity. If it is a case of nullity, affording opportunity to the incumbent would be a mere formality, and non-grant of opportunity may not vitiate the final decision of termination of services. The tribunal has rightly held that in the absence of prior approval of the competent authority, the director in charge could not have hastened issue of the appointment letter. The act of commission and omission of the then director would therefore suffer from the vice of lack of authority and lack of nullity in law. Again, my lord, para 25. Just two more paras, my lord. Para 25, it says, my lord, in so-and-so case, termination of the appellant therein, albeit without notice, was not interfered with by the court, as admittedly therein, as the same was not approved by the competent authority. The underlying principle will apply proprio vigor in the present case, as the letter of appointment has been issued by an officer who had no authority to do so, and also because it was issued without waiting for the approval of the competent authority. Resultantly, there was no necessity to afford, well, that part, not the issue here. In fact, so cause was issued. But the first part is very clear, my lord, from the two paras. In the next para also, reverting to the impugned decision of the High Court has not analyzed the efficacy of the crucial vision recorded in the subject office order dated so-and-so in its correct perspective. Indeed, the High Court has noted that prior approval of the competent authority was not mandatory. That observation, in our opinion, is manifestly wrong. We affirm the view expressed by the tribunal that the appointment of the respondent was not in conformity with the governing rules and executive instructions in that regard. Now, my lord, para 28, my lord, in between placetum C and D, my lord. In the present case, the letter of appointment could be issued by the designated director and only after grant of prior approval from the competent authority. Without such approval, the then director in charge in no case could have rushed through the process of issuing the letter of appointment and
This was
action.
the case where the person concerned who had issued the appointment letters,
He was not
Dr.
the
H.S.
applicant.
Rathore, he was an ad hoc appointee. And there were charges against him. And he actually was there for a very small time, but still he hastened to issue appointment letters. Now, can you draw a parallel?
My lord, the
fact
issue is
to-
not that,
fact
my
to
lord,
this,
whether he was on a
referencing to the fact
top
that-
game arrangement, my lord, he was there, he was issued it. The issue is, my lord, whether the authority who has issued the, my lord, appointment letter or has conducted the selection process, whether he is a competent authority or not. That is the entire
That's
issue.
all right, but we are stuck up at this, that you could find it only after 14 years. That's
That's
what
why,
is
my lord,
troubling us.
I pointed out in that page, my lord, that in 2017, this came to light. And then,
Therefore,
no,
you
lordship,
admit,
thereafter,
admit
the
that-
direction was issued by the
therefore
government.
you admit that it was a knee-jerk reaction. Because you found some to be working with a forced or fake appointment letters, so you conducted the inquiry, you broadened the width of the inquiry.
Yes, my lord.
And then you started. I mean, that,
No,
would that
my
be
lord,
permissible?
my lord, after coming into light, my lord, this illegality of appointment of the surveillance worker, the government directed that, my lord, the selection and whoever is working great for employees,
Did you
all-
did you put that to in the show cause notice to the respondents?
my lord.
You said that it does not have the SIU approval. Did you say that the appointment letter itself was a nullity because the person who appointed you?
Well, these are legal arguments that are being made, my lord. My lord, a rule
Legal
is there.
argument you can make. We are not saying that you can't make that argument. For the purposes of taking your arguments forward,
My lord.
we are asking you whether these respondents were made known that, well, this appointment itself was a nullity. No need to ask any question from you. You are a persona non grata so far as the government is concerned. Whatever you have earned, let it remain with you. We
Yes.
will not recover.
But that part, lordship will see, my lord, there is an order of this honorable court of the learned single bench, my lord. When, my lord, some publications were made in the newspaper also, that's all these, my lord, illegal, grade 4 employees who are presently working at that point of time, they were supposed to appear before a screening board. And the time of appearance, my lord, that lapsed. The writ petitioners herein, my lord, they, appellants herein, they approached this honorable court with the plea that, my lord, we are going to conduct the, my lord, screening of their, my lord, appointment and all without precisely giving what is the deficiency. The honorable court, after placing the instruction by the department, was pleased to direct that, my lord, whenever after the screening committee, if any illegality is found, that should be reflected in the so cause notice. And accordingly, my lord, so cause notice was issued to whoever, my lord, we have found that, my lord, their appointment is doubtful. And after the process, my lord, 412, my lord, employees have been, my lord, terminated. They were working, my lord, without, my lord, in fact, majority, my lord, except these two districts, all were, my lord, they are working without there being a, my lord, proper appointment letter being issued by the Director of Health Services, forged documents, forged signature, everything. When this process came up, my lord, it came to light and accordingly 412 were terminated. Now, my lord,
That's
though-
true, but I mean, there is a doctrine of severability where you had to assess the individual cases.
no,
We
yes.
don't say that you take or you retain every one of them.
No, doctrinal severability will come, my lord, when in a particular selection, say, my lord, 100% has been selected and appointed. In between, it came to light that, my lord, there is some illegality. And the inquiry is conducted and found that 20 are illegally appointed. They do not have the
That's
qualification.
right. That's
In
right.
that case, the severity will come. 80 will be protected because they have no, my lord, fault of their own. Because of this 20% who has got some, maybe the blue-eyed person of the selection board.
So therefore,
That is the severity, my lord.
sheet-
Here, my lord,
therefore, the sheet anchor of your argument is that this joint director,
in fact,
even though the director was in know of the entire fact,
no, he was
There
not
was-
aware, my lord. That also I will place, my lord. How, my lord, approvals are given. I will place, my lord. There is there in our affidavit that we have filed. Thus, my lord, thus few documents, my lord, I rely upon. That affidavit we have filed in the lead appeal, my lord, when this particular query was posed by the division bench, my lord, to us that whether, my lord, director is the competent authority, how we will prove it, my lord.
which division bench are you referring?
No, my lord, it was heard earlier also, my lord, not this bench, my lord. Of course, it was heard earlier and that issue we, my lord, tried to, my lord, reflected in a affidavit, my lord. It was filed in the writ appeal
Is
428.
is there any observation in any one of the orders?
No, when the issue was posed, my lord, we filed it, my lord, again, the pursuant to that, they have given the reply also. my lord. Just to show, my lord, there's some
No,
orders.
we just want to know whether it was observed by the bench which heard the matter earlier.
No, my lord, the issue was, question was posed, my lord, and accordingly, we tried to bring some documents into record, my lord, and they replied to that also. My lord, it was filed in WA number 428 of 2023. That, my lord, it starts at page number 1510. In WA 428-23, an affidavit. Now we will-
Mr. Gogoi, you will also be required to file a comprehensive note.
Lordship, but by
will not
yesterday,
be-
my lord, I could only, my lord, I got down my
Overnight,
appointment on.
overnight, this is
I
good
will-
enough.
Yes, I will provide the documents now. I will give a compilation.
At one place,
My,
give a compilation by the end of this week.
yes, I'm a black man.
The week ends today, I mean, the next week,
Yes, ma'am.
by next Friday.
I will, my lord, I will.
Then I think we will not waste time today.
Lordship.
You compile it,
Yes,
and on that day, we will just hear and maybe we dictate the judgment or we reserve it for future.
I will be obliged, my lord.
So next week, this bench would not
I-
be able,
I have filed.
this bench would be at Kohima, so therefore, you have time till Friday.
My lord.
we
I will
keep it-
take that.
Sometimes. 12th of December. we are keeping this matter for 12th of December.
My lord,
This is not for further arguments. You just, you would be given,
my submission.
you would be given an opportunity to argue
I will be,
and take us through all those documents.
yes, yes, my lord, I will. take-
And if you have to say anything on that day, you can come. 12th of December. Or maybe we keep it on 19th. Let us stop it. Well, all right. So on 12th of December,
My lord.
take it.
Let us file the compilation file 10 so that we have a look.
I think you have replied to his documents. So you will definitely get a copy of the compilation, Mr. Goswami, but no reply to reply. I mean, that's over. You will make oral submissions. If you inundate us with so many documents, I think we will again put it up for hearing. The points which are to be taken into consideration, if it's urgently required for you to rebut, then perhaps you can, but not otherwise, there should be any repetition. Arguments to continue. Let all these matters be listed for final determination on 12th of December. 12th of December.
My lord.
The
By
date-
Friday, I will give the compilation to the court master, my lord, for the new block.
Yes.
No bless.
And give a copy to. all.
I will serve to all, my lord.
Otherwise, we'll be lost in the maze of papers.
Yes, my lord.
We must have the reference points, no?
Lots of.
All. सबको अलग अलग करके रखोगे, कंफ्यूजन नहीं होना चाहिए। हिसाब का अलग रखना, मेरा अलग रखना, ये मैं लिखूंगा। क्या हम रख देना। बहुत सारा काम। हम्म?
Daily list for orders, item 1.
Yes, with your lordship,
Yes.
lordship, kindly pass over the matter for time being, lordship.
Well, in item 1, we are required to file an affidavit. Well, I have prepared the affidavit, but I am led by learned advocate general Assam in this case. But I could not vet the affidavit. She is absent, my lord.
As
I prefer 1 week time.
a prayer for Passover is made on behalf of the petitioner, Mr. Nath, learned advocate from the respondent, however, submits that some more time would be required for the affidavit, which is to file, requires to be vetted. Stop. Even otherwise, Mr. Nath has submitted that he is being led in this matter by the learned advocate general, who is not available today. Let this matter come up for consideration on. We keep it this part of the year or next year?
Lordship.
Next year.
Next. 2nd February.
My lord. Oh, no.
Item 2 for admission.
We need the photographs also. From where have you started?
Yes, yes. In our affidavit, we have sent.
Lordship, this matter is also laid by Sri Kiran Chaudhary. He is on legs in court number 25. Lordship, kindly pass over the matter only for time being, lordship.
Time being would be slightly difficult.
Only 15
Let's-
minutes, lordship, he is coming, lordship.
If the matter is not urgent, it can go.
No, lordship, we have urgency, lordship. Lordship, kindly allow me to call him
All right, passed over for the present.
for time being.
Without participating.
Item number 3.
Yes,
May I please your lordship, my lord, this petition is filed, telling, my lord, selling the by-race of Assam Land Acquisition Act 1964 and amended in
that
24.
be 250, Article 254(2). Ready?
Article to the article to the question.
You're ready, Mr. Nath and Mr. Bapu?
Lordship. This matter has come for the first time.
So you say yes, Lordship, so you have to respond to this.
Lordship, we have to
petition, no?
respond.
He has challenged the virus of it.
Yes, my lord.
He says that the Act of 1964, 64,
64.
despite the amendment in 2024,
Lord.
which has not received the president's assent,
No, it is a-
therefore under 254(2), it will be repugnant to the Central Act of 2013,
that is.
which is in list 3, connected to item number
42.
42.
Lord.
You have to respond to it, no?
Lord.
You say yes.
Yesterday.
So
the
but
matter.
the prayer should come from you. I should not give you time, no?
No, Lord, she has, this has come for the first time, Lord. Lord.
We will have to respond, my lord. We will file a detailed comprehensive
Yes.
affidavit. Similar matter was listed before.
We remember. Therefore we ask.
Lord.
Yesterday only.
Lord.
When have we put up that matter?
That matter is fixed for, my lord, 29th of January 2026.
Again, let counter affidavit in the matter be filed positively by the next date. Let this case be listed along with.
Along with my WPC 6172 of 2025. That was listed yesterday.
Along with so and so on so and so date. In the meantime, you are evicting them.
But the whole acquisition process is complete. We have issued notice under section 7 asking that.
They question the very legality of notice.
That one repetition is already pending before the honorable single judge. They are having not been succeeded, my lord. They have now filed the second repetition, wherein the challenge has been put to.
The same petitioners.
Yes,
Same
my lord.
petition.
Paragraph 8,
Same
my lord.
petition.
Para number 8, they have said that they have already filed a petition. It was a process, my lord, where already award is in past.
On 29th of January, then we don't do anything.
Lord.
Chalo, next.
Lord.
So,
Item number 4.
Compensation we will get. That's right. That's right. Yes,
May I please your lordship?
yes.
So here in the petitioner is schedule caste entrepreneur who has been exporting Bhut Jolokia, Assam Bhut Jolokia to the neighboring
Come to
states.
your prayer. Come to your prayer.
Yes, Your Honor.
Page 36 of your brief.
Yes, Your Honor.
Your first praise, stay all coercive actions against under the SARFACI Act 2002, including any action of possession. And then come to the prayer number 3 at page 37. Prayer,
Yes.
the first prayer at page 37. Dispose of the petitioner's representation dated so and so under section 13A.
Yes,
Don't you
Your Honor.
think your petition is premature?
Your Honor,
Want an order from us which will directly adversely affect you.
Your Honor,
Wait for the order, reasoned order passed by the bank, and thereafter you go before the DRT.
they have already replied to my representations.
They have replied.
Yes, Your
Then
Honor.
perhaps this petition has become infructuous. You
They,
need
ha-
to
they
think
have
that-
replied, but what?
Oh,
they-
Mr. Counsel, try and understand, though we have not allowed you to state facts,
Yes,
but we have straightaway taken you to the prayers.
yes, Your Honor.
Now, would this writ petition be maintainable?
Your Honor, there are some facts which.
Do we get into those facts?
Yes,
Yes.
certainly the point I just want to
See,
highlight is
look,
that.
there is an order passed under 13(3)A
Yes, that has been passed, Your Honor.
that has been passed.
Yes, Your Honor.
What is the forum available to you? A very, very strong forum
That is DRT, that is there.
before DRT. These issues are not to be.
Just before that, I just want to highlight just one point.
Why?
That is the terms that is.
You highlight everything before DRT. This petition is not maintainable. We don't say that. We say that you don't press this petition in order to agitate your claim before the DRT, if so
They
desired.
have, they have already taken the symbolic position issued 13 for notice.
Useless, no?
But the term that is DOC, which was not mentioned earlier in my sanction letters, later on, when they have revised my sanction letter, they have mentioned that DCCO.
DRT, you think DRT is toothless?
No, Your Honor.
Then after DRT, DRAT, and then you come before us.
Okay, Your Honor. Kindly a liberty maybe
After some liberty you have, I don't know what is the stage. First, you make a prayer, you don't amend your prayer later, and then you say that you get the liberty. We will say that in order to take down after some arguments, learned counsel for the petitioner seeks permission. What is your name?
Kunal Kande Sahara,
Mr. So and so, learned advocate for the petitioner seeks permission to withdraw this application in order to agitate his claim, if so advised and deemed necessary, before the appropriate forum. Dismissed as withdrawn with the liberty aforesaid.
Obliged to.
Item number 5.
Disputes.
Me, please, Your Lordship.
Here again, you come to your prayer, Mr.
Lordship.
The difficulty is that if this kind of writ petition is filed, I mean, it would lead to, orders where nothing is required to be done. Look at this, look at your prayer. Oh, no, this is, which matter is this?
Item 5.
This is,
Sorry, please argue your case.
Lordship, this.
Sorry, I thought it was again.
item 6.
Item 6, the private.
Similar situation is in item 6.
Yes, like, so sorry.
Here, Lordship, we are sealing the order dated 28/10/25 passed by learned CAT Lordship, whereby, my lord, this order has been obtained by suppressing the material fact that they have.
He has already
Availed.
availed for 3 years leave,
Yes.
Right.
36 months.
and this is the 36 months.
Yes. And as per
That's
service
3
law.
years.
Yes,
And that is the maximum leave that a
Yes,
person can have for
yes.
his academic
Yes.
accreditation,
yes,
correct?
yes.
So this was not noticed by the CAT.
Not noted.
Yes, what do you have to say?
They have suppressed this fact, Lordship.
No, I'll
Suppressed or not suppressed, the
Suppressed, Lordship.
tribunal did
But
not
in
take
fact-
notice of it.
In fact, my lord, they are harping on study leave rules.
Yes.
Lordship, where is this provision that only once a person can avail?
Oh, that's
That's an important factor, my lord. Lordship will kindly have a look. They are referring to page 109.
page 109.
First of all, my lord, I'd like to clarify one thing. The Honorable Tribunal, learned Tribunal directed for grant of UL, not for study leave.
That-
They are relying on study leave rule to
No,
challenge.
You are seeking 3 years leave.
Yes.
You are seeking, forget about what they did, what the tribunal did. Where is your application, which has been rejected?
My lord,
Show us your application, which has been
my
rejected.
application, my lord, will find page 98.
Hmm?
Page 98, my lord. Dated 31/7/2025.
What is this, sir? You have been selected for DM neurology course at Maharani Lakshmi. Why don't you quit the job? DM, you have been admitted to DM course. You will be earning so much. But the tribunal could not have directed the railways
No,
to
look.
give you leave.
My lord, may I just place the
What
fact?
will happen for 3 years? And they can't appoint a doctor on
Lordship.
contract. That is again their rules.
Yes.
No, this plea was never taken before the learned
It did not
tribunal.
be taken. It is
Fine,
being
fine. My
clear.
lord, may I just explain? My lord, the rule.
First things first, you raised an objection that this direction was to issue a leave to apply, to allow your application. Now the application is for what? Therefore, you have come to page 98.
Yes,
What
application
does it
for,
say?
I have been selected for DM. First of all, they have granted an NOC, my lord. They have granted an NOC permitting me to, my lord, appear in the examination, NEET SS. They appeared in the examination after due permission.
Lordship,
After
say right.
My lord, after that, my lord, after getting the admission and selection, I submitted this application asking for UL, my lord, study leave. Study leave was never considered.
Come to page 106.
Yes. This was when study leave was not considered. I was waiting for, my lord, their response. Then having no alternative, I submitted this application asking for UL.
Can you use all this strategy? Now, nobody stops you from pursuing your DM course. That's a
No, Lordship,
bigger
understand
course.
how difficult it is, difficult for a person to clear NEET SS, my lord. NEET super specialty.
We understand that, but
The all India, it's a lifetime opportunity for any person.
for any person, we understand that, quit the job then.
No, when the provision,
What?
my lord,
You,
when
the
the
railways,
provision is there,
where do you say,
my lord,
shows, just a minute. Mr.
I'm
Das,
sorry, I'm
Mr. Shows the rules which says that only once in life they can get UL or study leave for higher studies.
Lordship. That study rule, Lordship, just. Okay. My lord, page 109. Maximum amount of study leave. The maximum amount of study.
Maximum days.
The maximum amount of study leave which may be granted to a railway servant other than a railway medical service officer shall be ordinary 12 months at one time, or during his entire service 24 months in, this is for that. And number 2, Lordship, in respect of railway medical service officers, study leave may be granted for 36 months for acquiring the postgraduate qualification, subject to condition that railway medical service officer who has been granted study leave shall execute it. And here,
Special circumstances when no other leave is admissible and when other leave is admissible, but the railway servant applies in writing for the grant of extraordinary leave unless the. And now what is 530? Come to page 125.
Lord, I have just forwarded the complete portion of UL, my lord. Complete. There are 2 pages.
extraordinary leave.
Yes. Extraordinary leave may be granted when
The
there is no.
same thing, the second page was not there, my lord. Second page is here.
Just a minute.
I'm sorry.
No, just a minute. These rules shall apply to the investor. So this extraordinary leave cannot be for 3 years. Mr. Das.
My lord,
Yes.
may I just, lordship will kindly turn to second page.
Hmm.
Second page,
Note.
note 3. No limit in case of permanent railway servant, but all kinds of leave together shall not extend to 5 years in one spell. It's 5 years. Lordship is aware that if a person remains unauthorized absence, 5 years UL can be granted and it can be regularized. There are lots of judgments in this regard. And so far as page 109 is concerned, Lordship will kindly refer. There is no provision because for, my lord, this rule 2B and 2 is totally different. There is no provision in the rules that only once is for other railway servants, excluding the doctors. For doctors, it has been provided that there will be a bond of 8 years. That rider of my lord, executing a bond is not with respect to the normal railway servant, my lord. Lordship will kindly see the maximum amount of study leave which may be granted to a railway servant other than railway medical officer. Other than railway medical officer shall be. Now they are harping on 2B. During his entire service, 24 months in all, inclusive of similar kinds of leave for study leave, so and so, so and so. Now, sub-rule 2 is only for the doctors.
Yes.
It says in respect of railway medical service officers, study leave may be granted for 36 months for acquiring postgraduate qualification, subject to the condition that a railway medical service officer who has been granted such study leave shall execute a bond under sub-rule 8 or sub-rule 4 to serve the railway for a period of 8 years after completion of study. My lord, the process is that, my lord, I have to submit an application. The chief medical officer, who is the head of the Institute of Medical Department, she'll give a certificate. This certificate is with, my lord, covering 2 aspects, whether my absence will cause any problem whether my service will benefit the railway or not. That provision is also mentioned in these rules. After that certificate, my lord, how can they raise a plea which was never raised before the tribunal that there are dearth of officer and so on? MS Gill is, my lord, absolutely clear. And your lordship will kindly see the impugn order for a moment. 3-letter impugn order. Is this the way things should run, my lord?
Where is the?
Only
impugn order?
3-letter impugn order, my lord.
Only where is the impugn order?
And page 63, UL not agreed, 3-letter. This is the kind of impugn order they are issuing to jeopardize us, my lord, educational career. Lord, at the age of 54 years, 3 years he has prepared for, my lord, cracking this examination.
By
After that, look, suppression of,
Yes.
my lord,
You have
suppression of
obtained this by
material fact, my
suppressing
lord.
the material
When-
fact, my
when
lord, here
rule
you
does-
have obtained.
Look, when rule does not provide that only once, well, where is the, my lord, relevancy, whether I have previously availed study leave or not?
Verma should be transferred and posted in home. Which page?
Page 63, my lord. Impugn order before the learned tribunal.
Yes.
And learned tribunal has, my lord, categorically held
You
that
will not agree.
it is absolutely cryptic, my lord. And learned, which part of learned tribunal's order is erroneous, my lord? Let my learned friend show which
That-
part learned tribunal has taken into account all the details, all the grounds urged by them. Now they will come up on fresh ground.
Just a minute, you've said that, Mr. Das.
I'm sorry, my lord. I'm sorry. My apology.
Railway UL rules. Railway UL rules. No, liberalized delivery. Very extraordinary. Now, which UL rules is the tribunal referring to at page one
My lord, these
sixty-five?
2 pages I have given.
No, this is annexure 21.
Yes,
There is the
annexure
railway UL rules.
Yes,
Is this the UL rules?
yes, yes.
These are liberalized leave rules. And where is 5.3?
5 point, lordship is referring to page number?
No, we are referring to the judgment.
Yes,
Come to page 165, the third paragraph.
yes, my lord.
Third paragraph.
Yes, my lord.
Annexure 821 is the railway UL rules.
Yes, that is, my lord, I have just referred, my lord.
It is the same rules.
Yes,
UL
same.
rules are the
Yes,
same rules.
Yes, this is
Now-
basically IR.
Just a minute, please answer the question. No,
I'm so sorry. I'm
you're so full of your case, you will not allow the
No.
court to think.
Lordship, pardon me for
We
this.
we are looking at the rubric. It says Railway Services Liberalized Leave Rules 1949. Is it the same leave that the tribunal is referring to?
Yes,
Same rules. And then clause 5.3. Where do we get 5.3? It starts from 501.
lordship will kindly refer to page 125 of the paper book.
125 of the paper book.
Yes, sir.
Is the same thing.
Yes,
So 5.3, where is 5.3? 5.30, it begins at
530 extraordinary leave.
the tribunal says, tribunal account. 5.3. कौन सा कौन वाला फाइल? No limit was shown, but all things.
My lord, basically, my lord, perhaps there is some factual, yes. 5.3 is the UL, my lord, sorry, my lord, study leave rule, annexure 21.
So therefore, this
Some typographical error.
not some, huge typographical.
No, my lord will kindly have annexure 21. That is 5.3, my lord will find
Page,
page 108.
study leave.
Yes, ma'am.
So is she
Annexure
talking-
21, learned tribunal refer to annexure 21.
556.
Study leave, है ना? तो study leave for which we can't. I see.
This observation of the learned tribunal is with regard to my representation, my application for grant of UL. It provides
Yes, what do you want to show from here?
my lord, page 108, my lord,
Yes.
5.2.
Hmm.
It provides for 3 years. 5.3,
Just a minute, read that.
yes,
Who is not due.
who is
to
not,
age-
not due to reach the age of superannuation from the government service within 3 years, 8 years in so-and-so, so-and-so.
So therefore, you have many years to go.
Yes, my lord. 65 years,
65 years.
Yes.
You are how many years old now?
my lord, 54.
So eight years, yeah, yes.
Yes,
Who has
So-
been granted 36 months leave under sub rule 2 from the
Yes.
date on which he is expected to return to duty
yes.
after.
Now, sub Roman 3,
Hmm.
who executes a bond as laid down in 4.4 of the appendix 5 to study leave rules, rule 1, undertaking to serve the government for a period of 3 years, within bracket 8 years in case of railway medical service officer who has been granted 36 months study leave under sub rule 2 of rule 2 after the expiry of leave. Accordingly, railway servant having option to retire will not be permitted to retire unless he served the government for 3 years after return from study leave. Then, my lord, the rule 2 comes
Maximum
on
amount
which
of-
they are harping, which is not at all applicable.
Hmm.
And their whole ground of, my lord, only once in the entire career is absolutely fallacious, which can be gathered from here. And my lord will also kindly refer to page 107.
Just a minute.
I'm sorry.
There is no provision for studying again. So it has to be understood as maximum. The delay for and plus you will not be left with applications. And this is post graduation. Is the Yes, you are referring to page 110.
107, my lord.
107, we have already glossed over.
Rule 3. Study leave shall not be granted,
Yes.
down below, my lord,
Hmm.
unless it is certified by the authority competent to grant leave, the proposed course of study or training shall be of definite advantage from the point of view of the public interest. Now, provided that a medical officer may be granted study leave for prosecuting a course of postgraduate study in medical sciences in India, if the head of the medical department certifies to the effect that such study shall be valuable in increasing the efficiency of such medical officer in the performance of his duties. This certificate was given by the head of the medical
Read
officer,
further.
then only,
Read further, we have other
I'm sorry.
questions to ask you.
I'm sorry, my lord.
Hmm.
For postgraduate study in medical sciences abroad, my lord, this is not relevant for me, my lord, because I'm in India,
So now-
provided also.
So now, the study leave shall not be granted because if the burden is on the officer granting leave to you that he has to certify apart from the doctor, which you'll find it in the, which you'll file along with the application, that it is going to help. Now look at this. Of course, we are not, what is it? We are not nitpicking from the rules, but then it talks about postgraduate studies. DM is not a postgraduate study, it's a postgraduate. It's a postgraduate, which may not be required for better interest. For your personal benefit, it would be good, DM. Look at this, no? It says only
This is-
postgraduate everywhere.
My lord, all,
Everywhere it says postgraduate.
any graduate, any course after the graduation is, my lord, in normal parlance, it's, my lord, used as postgraduate.
Okay.
So DM is also, in my humble,
Something, a course where you have to be a postgraduate would also be a postgraduate.
sorry, my lord.
When basic qualification is postgraduate, for getting into higher studies, that will also be called a postgraduate. There are 3 equivalent higher posts like the DSc for science, which is Doctor of Science, PhD in arts, this is Doctor of Philosophy, and DM, this is Doctor of Medicine. So this is not a post-graduation study. That's luxury. I mean, though of course in private.
Further.
but,
My lord, with all due respect, my lord, with all due respect.
Tell us
Lord,
about this. Is this postgraduate?
My lord, in my humble submission, anything after graduation, because there is no provision. my lord,
That's a general,
this-
that's a
I
generic
understand,
understanding.
but the study leave rule does not contemplate, or there is
There is
nothing.
there is no service requirement under any branch in the government of India, in any field, where these post graduation degrees would be required
In the public.
as a matter of.
Public
as a
In,
matter of-
my lord, medical science, my lord, in medical
If-
science,
Just a minute, a study. So if he says no, you said 3-letter word, UL not agreed. Now, section, this subsection 3 at page 107,
my lord, their entire,
just a minute,
I'm sorry.
only when he has to grant leave for this course, he is to certify that it is for the advantage. He thinks that it is not for the advantage. Can
No,
we
he,
force him?
that is what I'm trying to convey. The head of the medical department has
That's the
conveyed
that's the application that you have said. This certification is.
this
Oh.
certificate, head, I'm sorry.
Study leave shall not be granted unless it is certified by the authority competent to grant leave. We are not concerned about your medical college
Fine, fine,
superintendent.
fine.
So he has to certify. Now, this is in response to your comment of the letter of rejection being 3-lettered only. See, if it would run in 5 paragraphs if the leave is being granted to you. Because the authority has to satisfy that your higher studies and your training would be advantageous to the employer from the point of view of public interest. So therefore they say that no, it is not interest. We don't want our doctors to be.
They never said, my
clear.
lord. That is the irony.
Oh, they have to say only when they grant leave. Otherwise they say rejected.
Fine,
Study
No,
leave shall
absolutely,
not be
fine,
granted unless
fine,
certification
fine,
is.
fine, fine.
So
Admitted.
thus we are looking at it from different
No,
angles.
I am also trying to convey.
Just a minute. We are looking at it from different angle, though the dice is loaded against you presently, you may upturn the situation. But the fact remains that here we are dealing with an employer and an employee. An employee has already taken a leave. Rules are slightly vague with respect to extension of this study leave. Now you apply for a study leave, when other leaves are not available to you, then you go for UL, liberalized leave rules. Correct. So liberalized leave rules, so you do it only here. No limit in case of permanent railway, but all kinds. You can always rest your case on the liberalized leave rules and not the study leave.
No. They considered my UL only. I never, I am in a situation, in a flex, my lord. Whatever you give me UL, you give me study leave, my lord. I have already taken admission in that particular college. Now, I am in a situation, my lord, whatever you give me, either UL or study leave, it is, my lord, helpful for me. So I begged before them. So the entire issue now before your lordship is with regard to EOL, because study leave chapter they have already closed. Study leave chapter they have already closed. They closed the study leave chapter saying that only once it can be availed. Although that is not legally correct.
No,
And,
but
and,
there is no provision also for second study leave.
and
There is no
not-
provision for second, otherwise you'll keep on studying and not serve.
normally, my lord,
You take salary and
normally
keep on
after,
acquiring degrees, which is not relevant for the purpose. As a railway doctor, you are required to see the blood pressure, you have to, make referrals to higher hospital.
normally after joining service,
No, but
this,
how can we
this
compel them? If the rules are not very specific, how can we compel? And you make an application.
Yes.
Though of course you have taken UL, but you say that you want to pursue this course. We have great sympathy with you because an ordinary student would not clear his NEET. It's a very serious, it's a very difficult
serious.
examination.
3 years I,
But then how do we compel the railways?
my lord, may I just point out one thing? What is their stand before the learned tribunal? Lordship will kindly have a look. What is their stand? Their entire stand was that, there is a departmental proceeding pending. I can appreciate, leave it.
24 months where the leave is required for the purpose of completing the study. This is in this is for ULA. Certified to be in public interest provided the railway servant concerned has completed 3 years continuous service. For 24. Railway to consider. This is over and above. So you will get it from the 2
Only one submission.
Mr. Das, we are contemplating of remitting the matter to the railways again for taking a call. There are two things. We rest assured that we are not going to stop you from acquiring higher degree. Not from our side. We will try our best to accommodate you, but this is a question of law. Now, look at UL again. There's 2 pages that you have said. Come to the next page, D. You have the copy?
Yes, my lord.
Now, this UL would be over and above your study leave. You can understand that. Look at this, read that.
24 months where the leave is required for the purpose of prosecuting studies certified to be in public interest, provided the railway servant concerned has completed 3 years continuous.
That is not relevant. You have completed many years.
Yes,
Now, this 24 months, UL also is for 24 months. When you require it for prosecuting studies, you have made it known that you have taken admission in a college.
yes.
So you get only for 24 months. No limit in case of permanent railway servants, but all kinds of leave together shall not exceed 5 years in one spell.
Yes.
In note 3.
3, my lord, 3A,
Now, let me,
3A
let
can be
us do
of-
one thing. We will ask the railways to pass a reason.
my lord, may I just point out one thing, my lord?
We are not granting you, we are not compelling them to do that. We will set aside the order passed by the tribunal.
My lord, before your lordships, my lord, take a view. May I just
No,
point out
this
one?
means tentative, we have changed by the minute.
No, that's why I'm trying, my lord.
Till the
And-
time we dictate.
My lord, I can appreciate, my lord, fine. My lord, you just did not want to assign the reasons in the impugn order. Although MS Gill says, I need not reiterate, my lord. But
Mohinder Singh Gill is on a different aspect altogether. It says that when your show cause notice is given to you, you respond to that, and a decision is taken on some other ground. That ground cannot be brought again.
Fine.
So
Milord,
MS Gill doesn't
Milord, I'm
apply.
absolutely fine, Milord. Mohinder Singh Gill also not applicable. When you file your written statement before the learned tribunal, is it an empty formality, Milord? What is their stand in the written statement before? Milord, elaborate written statement was filed before the learned tribunal, wherein they have urged only one ground. There was a departmental proceeding pending. Charge sheet was issued in the year 2020. Milord, may I
Just a minute, Mr. What is your name?
Lordship,
What is your name?
SS Roy, Lordship.
Mr. Roy, why don't you ask the railways? I mean,
Lordship.
they should consider the case of Mr. Das.
Lordship.
They should consider the case.
Lordship,
After all, he has many years of service left.
Lordship,
Now, if he procures this DM degree,
Lordship.
if he doesn't pass in 3 years, very well, you ask him to come and join, otherwise dismiss him from service, remove him from service. If not, why can't you give? Because he says that, well, UL liberalized rules
Lordship.
permit over and above the study leave,
Yes.
right? So he may have applied for study leave. He may have told you the reason for study leave, but he wants a study leave under this rule, under UL rule, not under that rule.
Lordship,
And here the certification would be required.
Lordship.
So why can't you consider it afresh?
Lordship, kindly see page 18.
Now, we will see everything, but why
Lordship.
can't you consider his case? Unless you have some, I mean, that he is facing a vigilance charge
Yes,
is something else. That has
Yes,
got nothing to do with the leave.
nothing to.
Therefore, he's what kind of vigilance?
Lordship, kindly see article of charges, Lordship, please.
Say,
Lordship,
tell us, don't ask us.
that
That is not relevant. That would only persuade us to think in his favor or against him. What kind of what kind of vigilance charge is he facing?
taking of gratification by granting false certificates.
This is what you're doing MD for, Mr. Das?
Enquiry officer concluded the enquiry and held the charges to be not proved.
No, this was again revert back, Lordship, that's
Lord, it was-
pending.
That is what I'm saying, Lord.
You're
Milord, allegations
seeking
may be
such high
anything.
degree for giving false certificate.
And after the charge sheet, they have granted me NOC. Lordship will also keep that in mind, Milord. After the, Milord, incident was of 2018, charge sheet was issued in 2020. Still 2025, they are, Milord, taking care of the charge sheet.
Mr. Roy, had he been interested in making money out of giving false certificates, he would not have come out of the railway administration to pursue his higher studies.
Lordship,
He is paying money.
Lord,
He is paying money for DM.
DM,
Yes.
but Lordship, kindly see our no objection 29/125. There clearly we have stated it may not be granted as a permission, Lordship.
It may not be granted as
The
a
permission to appear for the above mentioned examination does not convey any guarantee for your release in the event of your selection to the course when we are given to the NOC, Lordship.
Yeah, we have followed that.
Lordship,
This is what is holding us back.
Lord,
I mean, we should always help people in acquiring higher degrees.
Lordship.
No difficulty. Question is, can we compel the employer to grant? That is the only thing which is holding us back. And we will say that apply your mind to all these and
Lordship.
pass.
Lordship. Lordship.
That will not, they'll reject it, Milord. Lordship can pass order, Milord, but they'll reject, Milord, from the contemplation that has been projected in the writ petition.
You are not,
The-
you're not in their good books.
Milord, this
They
is
have put you
nothing,
into a
Milord,
department.
this is,
But see, we have our limitations. We can't.
Milord,
compel
I
them to-
understand, Milord, may I make one submission, Milord?
Suppose not.
I understand, Milord, I cannot claim leave as a matter of right, Milord. I cannot claim leave as a matter of right. But does it give them a license
No.
to deny it arbitrarily?
No. Therefore, we are remitting it.
Milord, is it a case that they did not get any opportunity? Milord, Lordship will kindly appreciate. Is it
All
the
right,
case?
if they deny you arbitrarily without any reason, we will look at it again. By that time, you have to take leave from the institution where you have taken admission. What do we do?
This, Milord, if I, for the sake of repetition, this contention of there, that there is, Milord, less number of doctor was never there. Milord, is it their case they did
Just a
not
minute,
get opportunity?
This order was stayed.
Yes.
The order
Which-
passed by the tribunal was put in abeyance. So you are serving the railways or you have already gone to take?
No, Milord, I'm serving here, Milord. Why should I go, Milord? I have completed 20 years of service. I joined in the year,
I'm
Milord,
asking you
19.
something else.
I'm sorry, Milord.
I'm saying that the course begins from a particular date.
August.
August.
They're lingering, my lord. They're delaying the thing so that,
Who are delaying the thing?
my lord, I submit-
Railways, I'm talking about the course. You are,
course started,
will they permit you to
yes, yes.
join midway?
Is,
And what will you learn after having lost for 6 months?
Lord,
And you will not be.
I'm
allowed
running out
to-
of time.
You'll not be allowed to write the examination without completing 3 years. In that case, you will seek another leave of 6 months.
My lord, I submitted my application within that period. my lord. It is they who took 4 months to forward my application, my lord. My lord, is it justifiable, my lord? Can it be, can a person be handled like this?
I mean, notwithstanding the fact that we are looking at the order of the tribunal, what we are worried about is that do we have the remit to compel them to grant you leave?
My lord, lordship can. If they fail to assign reason, my lord, a person cannot be, my lord, remediless. They got the opportunity
We are
before.
setting aside that order, remitting it to the railways, take a call, consider all this, give a reason.
Instead of that, my lord, lordship will keep this matter pending. Let them come up with a reason. Let us see what reason they assign. Let them come up with the reason so that lordship can take a call, my lord. No, my lord, lordship, they'll reject it, my lord. Lordship can send me to them, my lord. They'll reject it. 100%, my lord. A person should not be treated like this, my lord. DM is a lifetime opportunity, lordship is aware. I studied for more than 3.5 years after duty hours at night, my lord, and I have cracked this examination. And after that, and I'm willing to serve for 8 years.
We are giving them, see, the words used in the rules for leave. That's the discretion of the railways. So we are couching our order in such a way that without valid reason, they can't reject your act.
My lord,
We'll do that in a different way.
better, lord, if your lordship
Alright.
take my
Yes.
prayer, my lord, lordship will keep this matter pending.
Hmm.
They're crying that their, my lord, power, they have not been, my lord, given opportunity to exercise this power. Although they have exercised, but lordship
But there was some
will not
mistake,
cut.
but
I'm-
there was some mistake on your part also. You should have said in your application that earlier my employer was kind enough to grant me leave for 3 years to pursue my post-graduation course. I have passed my MD. Now again, I have taken admission in DM. I would require leave. If that leave is not possible under the study leave criteria, then I may be given my extraordinary leave. Clear averment should have been made by you in your application, along with the certification of the doctor that it shall be in public interest and your own oath that you shall serve for rest of the time in railways and will not run
Bond
away.
I have already executed.
Lordship kindly. see-
Bond I have already executed. Lordship is correct. The letter could have been properly worded. He is a doctor, my lord. He is not a lawyer, number one. Number two, this earlier leave, my lord, this lordship will kindly one aspect. This earlier leave is not with the. My lord,
This time we are asking you to write write a good order
Lordship,
where Mr. Das would be helping you.
Lordship.
May I just point out one
Kindly-
fact? This, my lord, earlier leave was not from the NF Railway.
Anyway,
In the,
for this doctor's leave, we have devoted more than half an hour.
my lord, I'm sorry, North Central Railway, that is, I was posted there in North Central Railway, Kanpur. This leave was taken at that time, not with the NF Railway. my lord.
Yes.
Even then, my lord, lordship will take a call, but lordship will not, my lord, send me.
Keep this matter pending. Now consider.
Lordship
a
kindly
fresh-
see, Lordship kindly see page 17, once Lordship. Kindly see page 17. please.
78.
So 17, Lordship. What was his application?
Kale to it.
Both salary.
17.
17, Lordship. This study leave application. I hereby declare that I have not availed study leave in past. I have applied for the study leave for the first time to the DM Neurology.
Have you done?
He must have, my lord, somebody must
Lordship,
have
this-
told him.
that's
he has
why I'm
written-
not-
But this is fraud, no?
Lordship.
This is fraud.
My lord,
Lordship.
records are with them. My
You
entire
keep
leave
writing-
record,
Mr. Das, can you justify this?
no.
Can you keep writing wrong facts to your employer? The authority is not only keeping the records of Mr. Das. whether he's correct or he is wrong.
I am not
he's
saying
right.
that, my lord. I am not saying that. I am not, I'll never defend, my lord.
The moment
I
you make
understand,
a
my
wrong
lord,
assertion,
this could have been properly drafted, properly written, my lord. Many things could have been written
not properly, you could have.
correctly.
I mean, factually correct.
Correct,
You're
my lord.
making a wrong statement.
Correct. My lord, this
By
was,
misleading this court, my lord,
No,
that
no, no.
order has been taken.
No, no.
Lordship. My submission is this, Lord.
my lord, my leave application, lordship will see.
Mr. Roy, he is already in trouble. Don't further trouble him and don't pester him.
My
unnecessarily.
UL application, my lord, will see page 105. Page 105. Sorry, my lord, this is subsequent.
यही तो लिखा।
My first UL application. Sorry, my lord, my study leave. Study leave application, my lord, will kindly have page 98.
Study leave is this.
Yes, my lord.
That is not page 98.
No,
Study leave is page 17.
page
17.
prior to that, my lord, page 98, 31/7/25.
Page 98.
98. This was like a reminder. My first application, which was considered, is page 98.
This was for, Mr. Das, again, yeah, this is a wrong statement. This is in continuation of the letter that you had given
On
seeking
29.
permission to appear in the examination. Mr. Das,
NOC.
Yes.
NOC, that's right.
NOC.
So therefore, this is not the study leave. After you have passed, this is the first study leave application that you are making.
Lordship.
After Milord
See, if
passing
you-
in the examination,
If
my lord.
if you make a statement which is capable of being misread or misunderstood
No,
or
no, my lord.
it will deflect the course of justice. No, this is statement we are, whatever sympathies we had in the beginning, that is gone.
No.
The doctor is making a wrong statement.
No, no, my lord. That can be, my lord. The 31/7/25 is the first.
Suppose he
application.
says that I would like to have this leave and he stops at that. He says, I hereby declare that I have not availed study leave in the past.
My lord,
What
is-
could be more specific? Is
No, no.
it inadvertence?
my lord, assuming he has availed study leave in the past.
Now, Mr. Das, we are not, doing it because of this statement
Milord,
of yours.
My lord,
Now,
may I just-
do you want the matter to be remitted to the railways or not?
my lord, my humble
Just
prayer.
call.
My lord, my humble prayer, my lord. My lord, my humble prayer.
Allow this writ petition,
My lord,
setting aside the order of the
Milord,
cat
my
on
humble-
our own grounds.
my lord, my humble prayer. Number one, my statement in this application, I did not avail leave, has got no relevance. Subject, my lord, correct, wrong. It's a wrong statement. I'm not saying. But from the point of view of rules,
Mr. Das, don't defend this, and this is not, a-
I'll not defend.
just a
I'll
minute,
not
this is not a wrong statement, this is a false.
False statement. My lord, I'll not defend. I'll not defend.
If this, Mr. Roy, you did not point out, otherwise you would not have gone to all those details. You make a wrong submission.
You know, this is an application given by.
Suppose
him.
you make a statement here that I have for the first time come to the High Court in the writ petition, though your writ petition was earlier dismissed. What will happen to the
Look,
person
I'm
who
an
swears?
officer of the court. My lord.
You means petitioner. What happens? Is that a statement which you should make?
My lord,
Now-
I'm
now
not
we-
defending this.
We are giving you there are only two options before
My
you. There
humble
is no
prayer-
third option.
My humble prayer, my lord, let the matter, at
You
least that much, let the matter be pending. Let them take a call, my lord. Lordship, sometimes man made mistakes, my lord. Lordship will not.
On this, you please trust us. We will say.
My lord, I have extreme faith before of this honorable court, my lord. That's why I am making that prayer, my lord. Let the petition remain, let them take a call, my lord. Let them exercise their discretion, my lord. If at any point of time they felt like.
All
they-
right, we don't agree to this suggestion. We will be highly sympathetic to you and we will ask the railways to consider this case, notwithstanding the fact that you made a wrong statement, which was under some kind of misnomer. We will say that you wanted to say that you have not availed any leave for pursuing this course.
Right.
We will modify
I'm
it.
good.
That's
But
what
I'm-
we can do
I'm good.
because of the efforts that you're doing and
I'm
I
good.
consider because he has been your employee. He has served you well.
20
Though
years.
you charge sheeted him in a domestic proceeding, but it has not culminated in any punishment to him. Please consider. That way he will stop issuing false certificates and he will try and treat the doctors,
So allegations
treat
are-
the patients.
Allegations are held to be not true by the IU. My lord. The Lordship will keep this, my lordship will
can
take
talk.
a call, my lord. Lordship will take a call, lordship will see the reasons what they assign, my lord. At least that much, my lord.
Taken.
Instead of. Lord,
The issue. As in, we have heard Sri Manso for the railways / petitioner and Mr. Das Puranavita for the respondent. The respondent is serving the railways as a medical officer. Prior to, he had earlier availed of 3 years study leave for pursuing his postgraduate course. Bracket, postgraduate course in. नहीं, क्या लिखा आपको? Namely, MD in neurology. Later, he required leave for 3 years for pursuing the course of DM neurology, which is a super specialization course, which is a super specialty course. The respondent also passed the NEET examination and secured his admission in the college, in the medical college, for pursuing such course. However, his study leave was rejected. Without assigning any reason by the competent authority. The respondent thereafter approached the tribunal, which on going through the study leave, ये तो extraordinary leave.
107.
क्या लिखा है? The tribunal क्या लिखा? Which on going through the study leave rules and the railway services liberalized leave within bracket, liberalized leave rules 1949. Directed the railways, that's petitioner, to grant leave to the respondent for 3 years to pursue his course. The railways have, the railways has challenged, the petitioner has challenged the aforementioned judgment of the tribunal on various grounds. Namely, that the respondent had earlier availed of a leave of 3 years for pursuing higher studies in MD medicine, MD neurology, DM neurology, MD medicine, while he was serving the North Central Railway. The study leave rules do not prescribe for any second leave in the life of an employee, be he a doctor serving in the railway medical service. The other reason for denying the leave, according to the petitioner, is that the respondent has been facing a major penalty departmental proceeding, bracket vigilance case, which is still pending. The last of the reasons urged before the tribunal was that the policy of the railway board is that no contract doctor could be appointed in place of a doctor going on long leave, long study leave / UL. And in the assessment of the employer / petitioner, the NF Railway would require the presence of the respondent as a medical officer. We have heard the learned counsel for the parties. We were aghast to see the application made by the respondent in the first instance, when he had made where he had made a statement that he had never availed of study leave in the past. Prima facie, this statement is incorrect. Admittedly, the respondent had taken medical leave, had taken study leave for pursuing his MD course. After having said that, we also realize, after having said that, we also reckon that perhaps the petitioner, perhaps the respondent would have meant that he had never applied for leave for pursuing BM course. As a serving doctor in the railways would always know that the records are available with the employer, and such false statement, if intended, could not pass. Nonetheless, we have examined the study leave rules and the extraordinary leave rules, which are called Railway Service Liberalized Leave Rules of 1949. A bare reading of those rules provide, a bare reading of the study leave rules provides, makes it clear that in respect of railway medical service officers, study leave may be granted for 36 months for acquiring postgraduate qualification, subject to the condition that railway medical service officer who has been granted such study leave shall execute a bond under sub rule 4 of rule 4 to serve the railways for a period of 8 years after completion of the study course. The respondent had availed of this provision and has been serving the railways after completion of the postgraduate course. There is no provision in the study service rules, study leave rules, for any further leave on that account, though not specifically stated, but could be gathered from the fact that the rules provide the maximum number of maximum period of study leave, which is for 36 months. When the study leave application of the respondent was rejected, he applied for extraordinary leave under the Railway Services Liberalized Leave Rules 1949. These rules provide that extraordinary leave may be granted to a railway servant in special circumstances, which have been enumerated, most of which relate to medical reasons, bracket illness of different kinds. One of the grounds on which the extraordinary leave could be availed of is for studies, is for higher studies. The relevant rule is prescribed in Rule 530, bracket D, which says that 24 months where the leave is required could be given for the purpose of prosecuting studies certified to be in public interest, provided the railway servant concerned has completed 3 years continuous service on the date of expiry of leave of the kind due and admissible under the rules, comma, including 3 months extraordinary leave under clause A. Stop. A note appended to the rules, bracket note 3, further provides that no limit in case of permanent railway servants, but all kinds of leave together shall not exceed 5 years in one spell. No, one if in one spell. Thus, the respondent could be entitled for an extraordinary leave over the study leave which he had already availed, and which could be for a duration for a period not more than 5 years. Not more than 5 years. Stop. It appears that the petitioner / employer did not actually consider these aspects of the matter before rejecting the application for leave of the respondent. Stop. Perhaps the employer was piqued by the fact that a false statement was made in the application for study leave, and that the respondent was facing domestic inquiry, not domestic inquiry, which facing inquiry on a facing domestic inquiry for charges of corruption. Stop. Mr. Das representing the respondent, Mr. Das, learned advocate representing the respondent side, that the inquiry officer has not found the allegations to be true, though the fact remains that the proceeding still remains pending. We therefore are of the considered view, keeping in mind that no person should be prevented from acquiring higher studies, but also simultaneously keeping in mind that by a judicial order, an employer cannot be compelled to grant leave to his employee. However, I said we have or considered opinion that we ought to remand the case to the authorities, railway authorities / petitioner, for taking a fresh call whether the respondent could be given leave for prosecuting his DM course, for which he has put in a lot of toil and has been successful in clearing the prestigious NEET examination, and has also secured admission in a medical college. Thus, we dispose of this writ petition with a direction to the respondent to file a fresh application before the railway authorities, stating correct facts, along with a copy of this order, within a period of 15 days from today, whereafter the competent authority to deal with such matters shall consider all aspects of the matter without being prejudiced by the fact that an erroneous statement was made in the earlier application preferred by the respondent, and shall pass a reasoned order in case of rejecting such request. Stop. This court expects that this court expects that the employer shall consider the case of the respondent sympathetically, and also keeping in mind that higher studies in the medical science by the respondent would be in public interest as also in the interest of the railways, provided the respondent is ready to work with the railways in future for the requisite number of years. We have also been informed that the respondent has several years of service to go before he superannuates. We say so for the reason that we have found such foibles on the part of the respondent because of his intense desire to go for higher studies, which also shall be taken into account by the railway administration / employer. The petition stands disposed of accordingly. We could not have lessened the rigor to an extent more than this.
But I am highly obliged, my lord, for that.
The decision in that regard must be taken within a period of 2 weeks from the date of filing of such pressure.
My course has already started. My course has already.
What can we do? We have
7 days,
we give you 1 week, that then give, we can lessen only this period.
1 week, madam. 1
He will file the application within a period of 1 week from today. Thereafter, 2 weeks, the order will be passed.
The order of, because they have filed a contempt petition before the
No, modify the order.
Everything goes.
lodge.
Timing item 2.
Highly obliged.
Wasted a lot of time. But yes. Yes, sir.
Yes, Mila.
He wants to say something.
There is a caveat.
Okay. It's all right.
My lord, the matter relates.
The caveat is filed for giving you notice that the matter is going to be heard. You're here. So caveat is discharged even before the application is heard. Yes,
My lord, the matter relates to settlement of a market, my lord.
yes.
Now, if your lordship would kindly come to page 28. Or rather 27, my lord. No, original one, no?
Yes,
Now, this NIT was issued, my lord, by the Nagaon Jilla Parishad for settlement of several markets for the period from 1/7/25 to 36/26. We are concerned with at page 28, serial number 4, Bali Khatra
Bali
Half-
Satra.
Bali Satra. That's the market, my lord. And the official government value was 83 lakhs and odd. Now, my lord, if your lordship would kindly come to clause 12 at page 30. My lord, this is an English rendered translation, my lord. The vernacular also have given. In respect of tender for all Bajar Ghat, the tender offering highest value between the average of settlement value of the previous 3 year and an increase within the cap of 10% of the 3 years average value will be accepted for consideration. Now, my lord, in the original tender, which is dated 7th of June 2025, my lord, that last 3 years average was not indicated.
Now that your lordship will get at page number 39, my lord. 39 is the, sorry, Asmi's version. My lord will kindly come to page 45. Yes. 45 is the, my lord, vernacular, page 43. This was on 16/6/25. It is hereby notified that the 3 years average of government value of the markets for
One-
its tender for settlement has been invited by the office of the Nagaon Jilla Parishad Right Office and note dated 7/6/25 and 10% increase thereon are as follows. Please come to serial number 1, 2, 3, 4, Milord, Bali Satra. Now the
Therefore,
last 3 years average was 1 lakh.
Maximum is 1 crore 62 lakhs.
Yes, and minimum is 1 crore 48 lakhs.
No, no, average value,
Huh.
it has to be minimum. 10% increase, but this is the maximum.
No, Milord. Now
Minimum
what
is
is
80.
what is most important in this?
Minimum is 80.
No, Milord. That is the point.
Government value is 80.
No, no.
They say that in the addendum, the clause 12 says that average of this plus maximum of a cap of this.
Yes. Now, my lord, for my lord, since my lord Justice Chaudhary is there, my lord, I'll just have his lordship's kind attention to page 45. Sorry, not sorry. Page 45, my lord. Kindly see, this is in continuation of 7/6/25. Then the last 3 years average value is 1 crore 48. If we add 10% to it, it becomes 1 crore 62. Now, my lord will kindly come to page 39.
No. This Asmi's rendition
Yes,
says that anything above the maximum of
between, my lord. That's why I was trying to draw his lordship's attention to page 39. Clause 12. Clause 12 of the original tender. সকলো বজাৰ ঘাটৰ ক্ষেত্ৰত বিগত ৩ বছৰৰ বন্দোবস্তিৰ গড় মূল্য সহিতে গড় মূল্যৰ 10% হাৰৰ ভিতৰত দাখিল কৰা সৰ্বোচ্চ নিবিদাহে বিবেচনাৰ কাৰণে গ্ৰহণ কৰা হ'ব। That means when we literally translate it into English, page 39, my lord, clause 12. সকলো বজাৰ ঘাটৰ ক্ষেত্ৰত বিগত ৩ বছৰৰ বন্দোবস্তিৰ গড় মূল্য সহিতে গড় মূল্যৰ 10% হাৰৰ ভিতৰত দাখিল কৰা সৰ্বোচ্চ নিবিদাহে বিবেচনা গ্ৰহণ কৰা হ'ব। That, yes, within. That means, my lord, whosoever bids highest bid between 148 and 160.
That's all right. So, Mr. Chaudhary,
Yes, my lord.
you did not participate.
No, I'm coming to that, my lord.
No, but let's come.
Yes, I have not participated. Why I did not participate?
Because it was confusing, vague.
It was not only vague, my lord. I thought, my lord, the value is high. I may not be in a position. No, my lord, I have seen, my lord, the settlement has been given for 84 lakhs.
84 or lesser?
Yes.
No, for lesser values.
No, 84.
It has been resettled at 62 lakhs.
Oh, no, no, my lord. At page 46, this is the impugned order of settlement. Page 46.
But there's somewhere it was.
Yes. It is 66. Now, my humble submission is, my lord,
How come?
if a bid between 148 and 162 alone will be considered for settlement, highest among that, how come either 66 or 84?
Give us that judgment of Reliance Energy Limited versus MSRDC and Schmidt Puts India Limited versus West Bengal. These are the places, these are the cases where a non-participant.
Has been permitted.
No, not permitted. On the complaint of a non-participant,
Tenders were set aside.
tenders were set aside because it was confusing, unfair, bad, or somewhat.
My lord, if I would have known,
Bring that judgment. Have you brought that judgment?
Today I have got, to be honest.
You have to.
I'm sorry, Milord.
Mr.
I'm
Chaudhary,
sorry, today I didn't come prepared with that judgment.
if you don't lead us, otherwise we will stop you here that whatever has happened.
Yes.
You are a non-participant. You
Yes.
chose not to
No,
contest.
I am a non-part, I'm not a busybody interloper as learned single judge would like to describe me.
No, that you are not. You have been,
In
a lot.
the repetition, I have made clear averment, Milord. When I saw the average value has gone up,
No, you were, in the past, you.
I was a set
you were a
lessee.
settlee. Therefore, this time you could not, but this idea dawned on you much later. But then these judgments say that, even a non-participant can bring to the notice because
Correct.
it is unfair, that should be level playing field, it is confusing and therefore did not appear, it will be unfair.
My lord, for example, I can give one example of service jurisprudence, my lord.
Well, that's all right, we are aware of this principle, no? But you must give us those reasons, we must have those reasons,
I'll get-
strong reasons. Because this is a stronger, we will not hear anything from a non-participant,
Yes, otherwise, normally.
otherwise.
So that way, in that case, lordship will have it on, my lord. 7th, sorry, 8th of, my lord. 8th.
Take them. Yes, you'll have to respond,
My lord.
Mr. Caveat, you'll have to respond. You're the person who has been settled.
Yes.
How come it has been settled for 62 lakhs? When the minimum government value was 84.
My lord, that point I can clarify, my lord, from the department. My lord, it was settled in, my lord, 84 lakhs, 1,001 rupee.
Then,
And my lord, this is for the whole year, my lord. But it was not started from 1st July. That is why it was reduced, my lord.
no, this is not for full year. This is for half a year. It's only half yearly settlement.
No, my lord. It's a full year, a panchayat year,
Okay.
starting from 1st July to 30th June.
Or therefore. So it
Yes,
has been
therefore that
settled-
was reduced. my lord.
It has been settled at the minimum.
Later point,
minimum
yes.
Government value that.
Yes. This is the first point, my lord. And second point, the locus, my lord, he was never participated. my
That
lord.
is a very strong point.
My lord.
But then he after reading the Assamese version of the tender, which my brother will say whether it is correct. What
My lord,
he
rule
was correct.
is in English, my lord. Rule is in English language. And rule will verify everything. Rule is in English language.
Says what?
Rule, my lord, Dr. may kindly come. Yes,
No, the whole. rule
In
is
the
not
judgment
quoted.
itself
The
is
relevant
quoted.
portion is not quoted.
judgment itself, my lord.
The appellant has questioned, we have heard Mr.
Yes.
We have heard Mr. K. N. Chaudhary, learned senior advocate for the appellant, and Mr.
As doctor,
S. Dato for
standing counsel, PNRD department.
respond number,
Respond number, my lord. 1, 2 and 4.
respond number 1, 2, and 4, and
DA Kayum for question number 5.
D. A. Kayum for
Question number 5.
respond number 5,
4 tomorrow, 3.
for private respond number 5,
And
And-
3, I think government advocate can
Yes.
take notice.
and MS R.B. Bora for the government of Assam. So the appellant has questioned the impugned judgment passed by a learned single judge in WPC number 6324 of 2025, whereby the contentions raised on behalf of the appellant that the settlement of Bazaar at Bali Satra was wrongly settled to respond number 5 has been rejected. Stop. The appellant claims himself to be an experienced bidder who had earlier managed the market successfully as a settlee. He was all prepared to participate in the tender issued for the year 2025, 2026. But for the confusing statement with respect to the reserve, with respect to the minimum reserve price. Stop. The half weekly market at Bali Satra was to be settled was to be settled by way of tender. for which the reserve price was fixed at 83 lakhs, 83 lakhs and 41.
401.
83 lakhs and 41. 041 at page 28.
Milad.
80 lakhs and 41. A note attached to the tender paper further clarified that in respect of tender for all bazaar/ghat, the tender offering highest value shall be between the average of the settlement value of previous 3 years, along with a cap of 10% increase over the average value. And the bid would be accepted within the range so prescribed. The contention of the appellant is that with the aforementioned wordings in clause 12, he and perhaps many others thought that the price was very high and therefore chose to restrain himself from participating in the bid. He has questioned the entire process on the ground that the tender terms were vague and confusing, which has the potency of preventing any meaningful participation. He further submits, the appellant further submits that with such confusing statement, there was no level playing field. And the settlement with respondent number 5 was on the minimum price, even when the average of the last 3 years settlement price exceeded a crore of rupees. Thus, the settlement also suffers from the vice of being unfair because public money, because there is a loss of public money. The learned counsel for respondent number 1, 2, and 3, Mr. Mr. Datto, learned counsel for respondents number 1, 2, and 3. However, 1, 2, and 4. 1, 2, and 4, however, expostulated that whatever may be the case, the learned single judge was justified in rejecting the claim, in rejecting the contention of the appellant for the reason that he was a known participant. A known participant has no locus to challenge the tender process. There could be no dispute about this proposition. But a non-participant can but challenge the proceedings, challenge the process, if he is able to demonstrate that the manner in which the process has been concluded affects public at large, or that the terms of the tender were confusing, preventing any meaningful participation. And in that event, the objection of such a non-participant would fall in public law review and not private grievance. The learned counsel appearing for respondent number 5 submits that he shall respond to this petition by the next date. Stop. Mr. Chaudhary, learned senior advocate for the appellant, also submits that he shall bring case laws on the subject to justify his stand that he, not being a busybody or an interloper, was prevented from being was prevented from participation because of the confusing reserve price and the note attached to the tender paper stating the maximum limit. What have I said? He shall bring. Comma, entitling him to question the process. Re-notify on
8 minutes.
We can have the proper translation for.
Yes, yes. Miller.
8th of January.
8th of December.
December, we are too tight. Let it go to January.
Look, otherwise there will be,
Nothing, the process, I mean, nothing shall happen. He also must get an opportunity.
if it is not
We have
inconvenient,
raised that
could it be on Millard 15th, Millard?
15th of January. 15th.
15th of January.
Or 17th?
17th of January.
Yes.
Gotcha.
Whole week is holiday.
কিন্তু না থাকি।
After that, that's due vacation.
Huh?
Due vacation.
17th is not a working day and we are
17 December, Millard.
17th December. 17th would be too early, you know. Keep it at 21st of this, 21st of December.
Okay.
But 21st is holiday, 19th of December,
92. Last day.
last.
Deeply.
We'll come back after 5.
Hello, please.
We'll come back after 5
Miller.
minutes. Yes,
Item number 6.
Wait, in this case, I want to approach the appropriate authority.
very good.
Yes,
Before we telling you anything,
yes, sir.
you go appropriate authority, you file a case against.
Yes, sir.
I mean, unless you file a case, what will happen?
Yes, sir. Correct.
After some arguments, Mr. What is your?
R. Sharma.
Mr. R. Sharma, learned advocate, seeks permission to withdraw this application in order to agitate his claim before the appropriate forum. Dismissed as withdrawn with the liberty of foresight.
I leave.
Item number 7.
For
Yes.
time being, any other court RF needs, sir.
Not time being, we have other matters today. It goes after something. The money, you are aware of the facts of the case?
No. He's any other court.
That's all right, but holding counsel, the junior counsel also should know the facts. Your money has been deposited in the government. So therefore, there is no urgency here. A prayer for Passover has been made on behalf of the appellant. So considering the board today, so such a prayer cannot be acceded to. Let this case come up for consideration January.
29 January. Item number 9.
May I please your lordship?
Yes.
Malad here assailing the order, malad passed by the runner single, malad my petition, malad here the fact of the case is very brief is that malad the matter pertains to provincialization of services, malad. I am the malad graduate teacher and malad that malad private respondent is malad junior to me. And malad his date of malad joining does not come under the purview of the act, which is a mandatory requirement for provincialization of services, malad. And his name also is not available in the 2019 Data, which is also a mandatory requirement, malad. So malad the prior provincialization of
Slowly. You- Yes.
my lord, the prior provincialization of my services, my lord.
Just a minute, we have passed some order. Independent. Yes. So your writ petition was dismissed on that account?
My lord.
Yes. Respond number 6. You appear for respond number 6. You'll have to argue this case.
Lordship.
Ready?
Lordship.
Bas karo. Because that, see, there cannot be any compromise in service matters.
Lordship.
And this was the fault of the lawyer.
Lordship.
So on that count, his claim cannot be, he has to prove his claim and you have to contest it.
Lordship.
Both of you are in service.
My lord, my service has not been provincialized, thereby, my lord, I am not continuing, and my continuation is not required. He is provincialized, my lord.
Who appears for the education department? Who appears for the education department? Mr. Gogoi, where are you going? You appear for the education department, no? Higher education. This is secondary.
Elementary.
Katniar. Where does he disappear? Ask him to be here. We will hear it on merits. It's not a question of, withdrawal of a case. That withdrawal was on wrong ground. Okay, his name is not shown. Just take, mention to Mr. Katniar about this case. Ask him to be here. Take down the land council for the parties are present. However, there is no appearance on behalf of. Anyway, let this matter come up for consideration.
My lord.
Tomorrow, day after tomorrow, when? After the olive oil. Let this matter come up for further consideration on after January.
After January.
After that. Reflecting the name of the Spani Council for Secondary Education Department.
Elementary, my
cause
lord.
list.
School education.
School education, Council for School Education, Secondary School,
My lord, the upper primary school, my lord, come under the school
Council
education.
for School Education
Education.
in the cause list.
My lord.
Offline.
February.
9th of February. Item number 10. Okay.
Yes.
May it please the Lordship. My lord, we are agreed by the order passed in the IA. That is how we are before Lordship, my lord. My lord, I'll rely upon one judgment, my lord.
No, you have to tell us the
Okay,
facts. We
okay.
don't remember the facts of.
Okay.
Did-
My
did-
lord, what had happened, my lord?
Did we say something on the last day?
Yes, sir.
Yes, Mr. Gogol.
Also, in last occasion, when matter was listed, also the impression was that the matter will be heard after the single bench judgment. Single bench matter is fixed on 8 laws.
No, nothing
Final-
like that.
Final consideration laws. Single bench.
No, that,
What impression did you gather? What did we say?
Lordship, that
What did we
Lordship
say?
may indicate that the matter will be final year after the single bench outcome was
Did we say that?
lost. That's why today I have, even Lordship, I am not bringing the file also today. Is the reason other. Otherwise, if Lordship, then I
that was not the understanding. At least we couldn't get any impression like that. All that we understood was
But
Lordship
then
was
there-
not
there is-
inclined
there
to
is-
pass an interim order. Lordship would like to dispose of the matter. That is how matter has been listed.
All right. So we, would you like this to be decided or you would wait for the, I
No,
mean,
no, my lord, the issue is like this. One point is involved there, one point is involved here.
so either, see, if this
No, my
petition,
lord, if I succeed in this,
that petition
then
would
that
not.
will become academic, that will automatically, because that is not even a point, my lord. Because they say for the financial year 24-25, we could not give the audited
So this
balance
is
sheet.
only rejection of an interim order.
My lord,
This is only for the, I mean, against the rejection of an interim order.
yes. No, my lord, the issue is LOA has been issued. Now tomorrow they will enter into agreement, further complications would arise.
No, so
A very simple point is involved, my lord.
LOA, who appears, who is the person in whose favor LOA has been issued?
Their party in the other case.
And here they are not.
Here they are not.
No, so
Because we approached this
they'll have to
honorable
be-
court at a stage when
That's right, but they'll have to be issued notice because it affects them, no? So why can't we hear all? I mean, why can't we allow the single judge to hear that matter and then we come here? Otherwise also in appeal, if you are aggrieved, come here in appeal. I think we will refer this matter also before the single, court. No, this is appeal.
Even
We can
Lordship,
keep it pending.
even my lord, honorable single judge has indicated Lordship, the
Like
matter
this.
will be heard on 8.
My lord,
Final
Learned
consideration.
single judge has passed an order in the other case. If a lordship should consider passing a similar order here, then it will okay. Can you see, my lord?
That's all right. So this covers you. This covers you. So let it go after it. Let it go after. Otherwise, the purpose of single judges.
No, I could quite see, my lord, justification because that matter needs to be heard, definitely. Because only one
Let
point
me-
is involved in this
Here,
other point.
Chaudhary, we can't hear you without issuing notice. So why two places? Probably I would not have granted this kind of relief. You have been granted. Why do also? Because in contract matters, normally I don't grant stay. I try and dispose it off.
Correct. No,
I mean, this
the
is
same-
my view.
The same, approach the learned single judge also approached. That is how
But
my
it's a
lord
subject
made
to
the
the
matter.
petition, which is whether.
And it's a huge project. That is also there. Second bridge over Brown.
Yes. So I think.
So lordship will have the matter on 9th. Let us see what happens on 8th, my lord.
Not nice. Then after.
No, my lord, let it come up on 9th. Lordship will kindly keep it for 9, my lord. 9th of December. Then they will be on 10th.
You will not finish on one day.
No, it will be finished. It's a small matter.
The other side will not finish.
They can't, my lord, because the learned single judge has given a time frame. They have to file their pleadings and all.
Let it be kept on 12th of December. 12th of December.
You know, 12th actually, my lord, there is some marriage in my family. Could it be on
Well,
15th, my lord, or 17th?
17th of December.
17th.
Let this matter
11
come
to
up
me.
for consideration. 17th of December.
If you like. Allah Jalus.
For hearing, item 11.
Yes.
That will perhaps recall that.
No,
Wait.
don't trust our memory so much. Don't trust our memory. We don't know. We remember the face of the advocate.
And as will kindly have the order dated 28th of July, which is the order by which this honorable court has admitted this appeal.
We have admitted this.
Yes, my lord. This is admitted for here.
Let's see what is it.
Kindly, my lords.
Is Mr. Sharma.
If I may read minutes from paragraph 2.
Yes.
The appellant has questioned the judgment and order dated so-and-so passed by the learned single judge of this court on so-and-so Kohima bench, whereby the challenge put up by the appellant has been rejected. The records reveal that the appellant and the respondent 4 participated in a 2-bit.
Who appears for respondent number 4? Who appears for respondent number 4?
Both the appellant as also the respondent 4 crossed the technical responsiveness threshold. Thereafter, the financial bids were opened. The learned counsel for the appellant has drawn the attention of this court to various clauses in the instructions to the bidders and the information regarding the procedure to be followed in asserting the tender papers of the participants. The method described in the NIT ITB was only the normal procedure of assessing the financial viability of the tender offered by taking into account the offer made by the party. He has further submitted that so far as technical assessment of the bid was concerned, it was good enough for a party's tender papers to have crossed the technical responsiveness front. Beyond that, it was only the assessment based on an offer made by the competing parties. The grievance raised on behalf of the appellant herein is that instead of the normal procedure, a new method, which perhaps was agreed to or formulated but only prior to floating of the NIT, was adopted. In that new method, each of the participants were awarded marks in the technical assessment and a weightage was given on such awarded marks in the technical assessment. It is the case of the appellant.
Yes.
It is the appellant that it lost out only because of scoring less in the technical assessment than respondent number 4, who could manage 100 marks. In any view of the matter, the learned counsel for the appellant submits that there can be no two opinions that in such matters, the choice of the employer cannot be bypassed. But the fault line lies in introducing a new method of assessment of the offer made by the parties, where marks were given and assessed on technical score, and on the basis of such marks, weightage was given to the parties. The learned single judge, on a perusal and assessment of all the case laws on the subject, came to the finding that it was not necessary for the respondent state to have gone for the lowest rate offer. Such decisions are based on other considerations also. So far, so good. But the question here is that whether it would be an acceptable method of computation when this process has not been made part of the NIT.
This is your argument.
Yes.
This is your argument.
Yes, Milords. That is all. It's a single ground appeal, Milords, and I'm only going to restrict everything to this appeal. I'm aware Milords have a best reference after this, Milords, which is why this is my case, Milords. Beyond this, Milords have only elaborated on this argument.
Let's read the whole.
Please, Milords. The second aspect of the matter, which was highlighted by the learned counsel for the appellant, is that even the final result was never uploaded, and the appellant could know about the work order having been given to respondent number 4 only when it applied for such information under the RTI. He therefore directly infers that the entire assessment process of the tender papers was under cloak and dagger and therefore vitiated. On our query, Ms. So-and-so learned additional Advocate General Nagaland has informed this court that respondent 4 has now completed the work up to the extent of 39% up till now. Mr. So-and-so, learned advocate representing respondent 4, submits that he shall be filing his response to the memorandum of appeal by the.
Has that been filed?
Yes, has been. This is the case, Milords.
Is any case law that you can?
Indeed, Milords. Milords have given a compilation for your lordships. Milords, Datta Associates, Milords are very well aware of that it will apply. However, Milords, there is a division bench judgment of the Honorable Delhi High Court, which I would like to press into service, Milords. There is a list, which I'm also giving for my learned counsel to the other side. Milords, this is at page 7. Orion Security, this is a judgment which has been authored by your lordship, the Honorable Chief Justice, Milords. This is at page 7 of the compilation. This relies upon Datta Associates. And for a moment, Milords, if I can impress upon your lordship the facts of this case, this judgment that I'm relying upon at page 7. In Orion Security, Milords, a tender was floated for getting security people, security staff in 4 clusters of the Education Department of the Government of NCT of Delhi. Now, there was a stipulation in the NIT that there will be an agency rate that each tenderer will have to quote. That agency rate has to be above 5%. This was in the tender. Subsequently, a clarification was issued that no such 5% stipulation is going to be there. The agency rate just has to be above 0 or nearly. The appellant in this case, Orion Security, they quoted a bid for all clusters where agency rate they specified as ₹1.
Now I remember, this
Yes.
was sometimes in 2015 that I had
Indeed,
decided.
indeed.
Reported in 16, but in 2015.
Yes.
Yeah.
In a division bench, my lords, we sitting. And in this case, my lords, what happened after that was in 3 out of 4 clusters, the bid of respondent of the appellant herein, although he was the lowest bidder, was rejected on the ground that rupee 1 is an obscurely low or commercially unviable agency rate to be quoted. That is the reason which was given. Now, if my lords will kindly see, only for the clarification of the facts of the case, my lords, para 19, which was the reason which was given, which was the reason which was given for not accepting the bid or reject, para 19 at page 10, my lords, para 19 at page 10. Within quotes, my lords, this is the reasoning which has been given, and my lords will kindly bear in mind, in our case, nothing of this sort exists, no reasons. The CS is also a simple table which contains numbers, no reasons. However, my lords, in this case, this is relevant. If I may read, my lords, within the quotes. After considering all aspects and advice of the finance department, so-and-so, along with a reference case of Honorable High Court and so-and-so, by order dated so-and-so, the committee observed that it is not feasible by the bidders to meet all expenses towards wage dispersal, administrative charges, leave, maintenance, so-and-so, and all statutory obligations to the security guards, which is applicable as per Minimum Wages Act and labor laws, on the service charges quoted by the bidders. Hence, the committee unanimously recommends to reject the e-tender on the ground of unduly low and unworkable rates quoted as agency charges, that is rupee 1, by Messrs. So-and-so in clusters B, C, and D, and agency charges, that is rupees 412, quoted by Messrs. So-and-so in cluster A, which are non-responsive. Now, my lords, for the ratio of this case, my lords will kindly come directly to
para 47.
Yes, my lords. My lords will kindly, first, my lords, if I may, my lords, at para 35 at page 12, my lords will kindly see. Because I'm only pointing this out because, my lords, on the last day when this matter was mentioned, Lordship had asked me a pointed query that what is wrong with UCBS and why should the L1 be given this contract, my lords? That was your Lordship's question. This is my answer in the words of this judgment, my lords. At para 35 at page 12, my lords. In any public contract, the decision is required to be an informed decision and it should not be arbitrary, illegal, or based on irrelevant considerations. If the decision is based on irrelevant consideration or it overlooks relevant considerations, it has necessarily to be termed as arbitrary. Now, my lords, in a publicized government contract, it is always expected that the lowest bid would be accepted. A possible exception being its commercial unviability. An agency inviting tender has the discretion to accept or reject the tenders, which includes the right to reject even lowest tender. But such decision has to be based on objective considerations relatable to the requirements in the tender notice and the contract requirements to be performed. It would only be a repetition of sorts regarding the requirement of the state in all circumstances to act in an objective, fair, and reasonable manner. Again, at the cost of repetition, it is being stated here that if the basic minimum rate is stipulated in the tender, any bid quoting a lesser rate than the stipulated level is bound to be rejected. And no grievance could be raised on the avowed reasoning of benefit to the public exchequer. But if there is no such stipulation of any base rate, a governmental authority cannot assume that the rates quoted by a bidder is unviable or unworkable. It is squarely applicable in my case in support of the appellant's case.
No,
and I'll demonstrate.
that's with respect to the cost.
Yes.
No, we are not at cost.
Yes, ma'am.
Cost, I think much water has flown in Brahmaputra thereafter. This is 2016. Now all the Supreme Court decisions say that please don't look at the cost. This is an instruction to the courts,
Yes.
a self-limiting kind of,
Certainly.
prohibition.
Certainly.
That cost you please don't look into.
Certainly.
Viability or unviability, the state knows, the employer knows. But then what you can agitate even today is that this marking on the technical assessment,
Yes.
whether that was part of the
Sir,
whether
if I
that was
can
part of
bring
the-
your lordships directly to that, Milords, I'll first make the submission. There are 4 clauses in the contract, in the tender, Milords, in the ITB. At page 100, Milords, I'll not take your lordships to that. 25.1, 25.2, 26.1, and 27.1, which govern how the evaluation is to be done. Now, the process of evaluation in this ITB was, Milords, that first, the tender committee would check the technical substantial compliance of the bids. They would see whether clause 3 and clause 4 at page 90, Milords, are complied with. I have complied. That is at page 508. And so has respondent number 4.
No, that's all right. So we reduce it in one line.
Yes.
That after you cross the technical
Yes.
threshold, then it is only the price which is to be considered.
Yes, L1,
Because how far were you technically viable?
yes.
That is not a question, but
was-
then they decided about the procedure before.
Yes, which
So
was never
that-
there, it was never a part of the NIP.
Isn't it? So therefore, you have to tell us, you have to satisfy us that you see, there are various ways in which an assessment can be made.
Sir.
That cannot be part of the tender paper, suppose technical evaluation. So this is not something new that they're adding to, if you touch the baseline and somebody has a better qualification technically. So whether assessment on that count would be considered to be a totally new fact which has thrown you off guard.
Sir.
Which can throw anybody off guard. So for that, you will have to tell us, because this is something which is really difficult, especially at the present time. What is your name, Mr. Counsel?
It's the A Gotham, that's Angaj Gotham.
You practice here?
Indeed.
All right. I thought you were from Delhi.
I was in Delhi, because I deviled in Mr. Siddharth Luthra's chambers.
You appeared with?
I deviled with Mr. Siddharth Luthra.
Okay.
I was there for
That's why your
5 years.
face appears very familiar.
I had, when I was an intern, Mulaz, I had to regularly attend your lordship's court. Mulaz.
Okay, therefore, I mean,
Yes.
there is some memory of old times.
Indeed, Mulaz.
Hmm. Now, especially at this stage, Mr. Gautam,
Yes, Mulaz.
Mr. Gautam.
Yes.
Especially at this stage when the other respondent has got the work and some work has progressed. Now, at this stage and of course, it's not your fault, you have immediately gone to the authorities and no stay order, but do we upturn it now on that ground? Now you'll have to have a very strong reason.
Certain.
This does not, I mean, one price, I think my judgment is an old one.
But I
So we
think,
have said this, I mean, the correct proposition of law is there,
yes,
but then it's an old one. The recent trend is that no, we will not look at it. If somebody has better experience, less cost also the government can bear.
indeed.
And that the court should not be worried about the public exchequer unless there is some fraud or something, some collusion. So we are not looking at it. We are only at that point that this assessment part, should there be an intimation to the parties? Does it throw you off guard?
Certain.
So that you'll have to.
If I may. There are, from what I understand about what is flown from your lordship. Firstly, regarding the selection methodology. Had there been any other selection methodology in place?
We will hear you on some other date. Because the other side also has to argue, and we will be only dealing with death reference now. Immediately after, next week, we are not available.
After that week, Mulaz.
After that,
Any date, Mulaz. Any date that your lordship.
9 December.
Great.
Get ready, all of you. Your Kechi. Nagar. Kechi and your Jamir.
Because I have some urgency, Mulaz. 9th is the first hearing day, Mulaz. On Tuesday, it will be convenient. Mulaz. It can be completed on 11th then. Mulaz.
11th. Why? First week, Hornbill Festival ends by 10th, no? Oh, Christmas. Alright. That way you will be in difficult position till the end of this year. Till December. Huh?
Mulaz, may keep, if not inconvenient, 11th and 16th Mulaz. Because it'll take a little bit of time, Mulaz, the final hearing. 11th and 16th thereafter, Mulaz. He can complete his reply on 16th.
16th of December.
Great.
All right. We have heard Sri
A Gotham.
A. Gautam Learned Advocate for the appellant, है ना? For the appellant, and so and so for the respondents. Arguments to continue further. Re-notify, so and so. Get some judgment on that.
Mulaz.
I think this compilation, Datta Associates is all right, but it doesn't squarely cover that new fact situation.
Mulaz, I'll satisfy Mulaz. With reference to their own case, they've demolished it in para 5 of their affidavit in opposition. They say that they got the methodology from the general financial rules. The general financial rules say that your RFP will have to specify that you are going to use QCBS. That is, their own admission demolishes their entire case. Para 5.
Para
Of-
5, what have they said in para 5?
Para 5 of the state's affidavit in opposition, they quote Rule 193 of the GFR, which begins with the words, the RFP shall specify that QCBS, when you're adopting, this will be the ratio of marks.
MS Kechi and Mr. Jamir, he is arguing on the demurrer. Therefore, the first right of hearing shall be of you. He is arguing on demurrer, your affidavit.
Yes.